Is Florida's stand your ground law unconstitutional? I am attorney Janair Hines. I am a criminal defense attorney here in Tampa, Florida. And today I'd like to discuss with you whether Florida's stand your ground law is indeed unconstitutional. This has come into the news recently because a Miami judge decided that it is unconstitutional. The stand your ground law is something that most Floridians are quite familiar with. It's something that was enacted back in 2005 and that has come before the courts several times since then. However, the Florida legislature and Governor Rick Scott signed into law last month a new measure that essentially alters the Florida stand your ground law. This is essentially what the judge decided is unconstitutional. When the stand your ground law was written in 2005, the Florida legislature created this hearing. The purpose of the hearing was to determine whether someone was entitled to the stand your ground immunity or not. It went before the Florida Supreme Court, and the Florida Supreme Court determined that the defendant would have the responsibility of proving by a preponderance of the evidence that they were in fact entitled to the stand your ground immunity. At this hearing, if it's determined that the person is entitled to the immunity, the case is over, doesn't go to trial. But if it's determined that the person is not entitled to the immunity, or it's not clear whether the person is entitled to the immunity, then it would go in front of a jury to decide the entire case. Last month, Rick Scott signed into law a bill from the legislature that essentially shifts the burden. What it does is, instead of the defense having to show that they are entitled to the immunity, the state would have to prove that they are not entitled to the immunity. It also raised the standard from preponderance of the evidence, which is like a 51%, to clear and convincing evidence, which is more 75%. Now that's oversimplifying, but the percentages give you an idea of that kind of raising the bar and putting it on the state to make it a lot more difficult. The Miami judge determined that this new measure was unconstitutional because of separation of powers. Under the Florida Constitution, the state legislature is responsible for creating substantive law, while the state courts are responsible for creating procedural law. The Miami judge has argued is that by going in and changing the procedure of the hearing, essentially the Florida legislature is overstepping their power and stepping on the toes of the Florida courts. There are other arguments on both sides of this. Proponents for the law have stated that this was just a clarification of the intent of the actual law rather than creating a new procedure. What this new law is going to do is make it easier for people to get away with murder. And I mean, there are many groups of Americans right now who may not believe that that is the direction that we want to go in. You have to consider, well, what is the real purpose behind this? Is this for the citizens of the state of Florida, or maybe some entity who stands to benefit from such a law? So, to wrap this up, what's going to happen now? Essentially, it's probably going to end up back in front of the Florida Supreme Court. This issue will be litigated, and there will be the arguments made, same as the ones that have been made in Miami. It is in the interest of the state that we have consistent laws that apply the same throughout the state of Florida. So, thank you for listening.